Hello, everyone, and welcome to Uncivil Law for what is probably going to be a very quick live react stream. So, I did not schedule this and I did not announce this except by posting it on YouTube. So, it's probably going to be pretty quick, but I wanted to do it live so it would be a genuine reaction. So, my friend and yours, Leonard French of Lawful Masses, already did a story on this, but I haven't listened to his story and I haven't listened to the audio because I want to share my reactions with you. So the story is Mr. Bank was arguing a case before the Second Circuit Court of Appeals on what I'm not exactly sure. And apparently at the Second Circuit, Mr. Bank had 10 minutes for oral argument. Now, most courts of appeal, I think, are 15 minutes. The U.S. Supreme Court is 30 minutes, but he got 10 minutes. So 10 minutes is a little short for an oral argument. In fact, it's incredibly short for an oral argument. 15 is more common, but I guess the Second Circuit's going to do what they're going to do. But it did not take 10 minutes for him to give his oral argument. It took 3.5 minutes for his oral argument. And it took 3.5 minutes because he immediately basically got in the face of the judges, because remember, it's the Court of Appeals, so there's a 3-judge panel. Apparently immediately blew up in the face of the judges and had to be escorted out of the building. Very exciting. So we're going to listen and live react to this audio, which I have not heard before. I hadn't heard, Leonard French's coverage of it, but I just wanted to listen. We will listen to the 3.5 minutes of audio and we will comment on it as it goes. So let's get started with this. Very super exciting. 3.5 minutes and thrown out of the building. All right, here we go, kids.
Morning. I represent Robert Doyle, the appellant. I think our briefs were rather thorough, and at least to my satisfaction, addressed all of the issues, having reviewed the opening brief and obviously the reply brief.
Sorry,
as well.
I think the audio was muted there for a second, so let's start over.
I represent Robert Doyle, the appellant. I think our briefs were rather thorough, and at least to my satisfaction, addressed all of the issues, having reviewed the opening brief and obviously the reply brief as well. So my question is whether the court has any questions, because otherwise I'd just be essentially reading from or reiterating the points in my brief, which I'm assuming the court is familiar with the issues. So my question is, are there any questions?
You know, this is not how I would do this if you want to do this. Like, given that you only have 10 minutes total, the idea behind this isn't necessarily bad. It's like just yielding basically all the time for the court. Like, if you really feel like if you've said everything in the briefs, if you really feel like it's clear, if you really feel like you've explained everything and, you don't really have anything more to add, then like this idea isn't necessarily bad. Basically saying like, but this is not the way I would phrase this. The way I would do this is I would have like just a paragraph or 2 or 3 of just like a very brief summary of, the nature of the case, the key issue at law, our key arguments, and then basically say, do you have any questions? So like without knowing what he's arguing about, without knowing the case, I can't rewrite it. But the way that he's phrased this is very passive aggressive. And this idea isn't bad. But he's being very passive aggressive with like, we've laid it out on the briefs, and I assume you've read the briefs, and like, just want to know if you have any questions. Like the idea that he's going for is not necessarily bad. Don't know if I would do it this way. I only have 10 minutes, so like, this is not necessarily a bad idea. I've laid everything out in the briefs, and so just basically like give a very short introduction. So we've kind of seen this in some of the Supreme Court oral audio already, where basically you have that 2 minutes introduction. So I'd be writing like 1 minute, 1 minute 10, sort of 1 minute 30 introduction of the case, and like stopping. So I'd be trying to basically get this under 60 seconds. But then I'd be like, and if there are, so if there are any further, if there are any, and then I basically say, once I've laid out the introduction, and if there are any questions from the court, I'm happy to answer them. And just stand there and see if they ask me anything. But I would not phrase it this way. This is very passively aggressively phrased. Right idea, very bad phrasing. Let's move on.
No question.
I have a question.
Okay.
I don't understand why the appeal is brought. I mean, your client controls whatever affidavit he submits to get admitted, and if it's not an affidavit that he likes, he doesn't need to submit it. So I don't understand why you're here.
It's not a question of whether he likes an affidavit.
His due process concern is that because he has to submit an affidavit, if the affidavit is negative, then that somehow hurts him. But he controls who he gets an affidavit from, and he controls whether to submit it. And if he doesn't like an affidavit, he can go get another one, right?
His fear of a negative affidavit, Judge, with all due respect, has nothing to do with this case. That
was the explanation on what the perceived injury is.
No, it wasn't that at all.
What's the injury?
I wouldn't come out and say no like that. That's just it's too much. It's too aggressive. I'd say, I'd say something like, respectfully, Your Honor, I think that is a side element. The real issue here is X, Y, Z. I'd say something like, trying not to completely dismiss what he's saying if I thought it was irrelevant. I'd say something like, with respect to Your Honor, I feel that's a side element, and our principal issue is whatever our principal issue is. The judge is allowed to say no to you. You're not allowed to say no to the judge, especially to a court of appeals judge. You have to think of more tactful ways of correcting the court when they make a mistake, when they misunderstand something. You don't. They are the judge. When they say tell it to the judge, they are the judge. So the judge has laid out what he thinks the issue is. It's like, I don't understand why you're here. Your client appears to have some due process concerns, but he's in control of the affidavit. So, like, if he's worried about a negative affidavit, he can get a different affidavit, or he can rewrite the affidavit. He doesn't have to submit it. He's in total control. So it's like, I don't understand what you're appealing on. That would be a perfectly logical thing for the judge if he thought that was the issue. A perfectly reasonable question. If it's not the issue, then I, as the attorney, am thinking I've perhaps not highlighted it properly, not drawn it out properly, or that's somehow irrelevant, but I would not say no. So let's press on.
Are you serious, Judge? With all...
Oh no. Oh no. Ooh. Oh my word. Okay, and that's when it was all over. Ever. That was when the case ended. Let's press on. Pro tip: do not say, "Are you serious, Judge?" Not a good idea. Let's press on.
No, with all due respect, I
It's a little late for the all due respect line.
don't know what to say.
You know what? I withdraw my question. You can sit down.
Okay, well, thank you.
Thank you.
Thank you very much, Judge.
The judge says, "I withdraw my question. You can sit down." And so the judge is like, "Oh wow," it's like, oof. It's like, I don't know, like, I don't know if I were in this space, like, how I try to rehabilitate this. I might, if I had gotten this far, I might try to, like, basically say, that was really rude of me and disrespectful. I apologize. If you'd like to rephrase your question, I don't know if the judge would want to, but yeah, I don't know that I'd sit down. I might try to rehabilitate this, but the judge is like, just basically said you're going to lose this case in so many words, and I don't blame him. And okay, let's press on.
We'll hear from,
I see that you read the briefs thoroughly.
Ooh, I see that you read the briefs thoroughly. Ooh, 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 snide comment. Oh no. Oh, it goes from worse to worse. It's completely possible the judge did not read the brief or skim the brief, but like, you do not like call out the judge. Not for the least of reasons that judges like work different ways. Some like to like rely on the oral argument more. So like a whole bunch of things are possible, but you never call out the judge and you never say passive aggressively, I see that you read the briefs real thoroughly. This is not good trial practice, or I guess to be more appropriately, this is not good appellate practice. This is not really what I would recommend you do when trying to talk to a judge. Wow. And he just had to come up with that line. Like, I see you read the briefs real carefully. You just know at this point it's going downhill. Oh my God.
listen, you are acting inappropriately. You are acting inappropriately.
I'm sorry.
Well, you are acting in a disrespectful and discourteous manner, and that's not appropriate.
The judge is trying to give him a bye. Which, good for the judge trying to de-escalate the situation. I mean, I can totally see like the judge just escalating and them both escalating. So good on the judge for de-escalating the situation, or at least trying to. Saying, look, you're being disrespectful. Now, the lawyer, having been called out, should like throw himself on mercy and like say, I apologize for my comments, and I'm sorry, and I don't know what you say to try to dig yourself out of this hole at this point, but basically just plead and throw yourself on the court, and the judge is trying to give him an out. Will he take it?
Good morning, Your Honors. Assistant United States Attorney Matthew Montefiore from the Eastern District.
Okay, so the opposing side is now up. So the opposing side is now up. So he didn't start talking until like about a minute and a half. It's now 2.5 minutes. So his entire oral argument was 1 minute. If the assistant U.S. attorney should probably, I don't know what the right move here is for the assistant U.S. attorney. Probably just ignore everything that happened and just try to present the case like none of that happened is probably the best move. If you're feeling very charitable and can think of a way to like dig your opponent out of a hole they've dug themselves into, that might be nice, but probably just ignoring it and just pressing on like none of that happened is the best way to go.
District of New York, on behalf of defendant appellee, the district court properly dismissed this action for failure to state a claim. And unless the court has any questions for us, we rest on our arguments set forth in our brief.
All right, thank you. We'll reserve.
That is like, it's not necessarily, it's a little short, but I think the U.S. attorney was being a little short because the opposing side was very, very short. But it's respectful, it's properly. I mean, he knows he's won, right? He knows he's won the argument. So like, there's no real reason to talk, but I don't know. I think if I were in his position, I might try to like just lay out the case anyway. Like basically pretend like my opponent actually gave a good argument and give like my introduction and then sit down. So I don't know that I necessarily follow this, but it's a reasonable move.
Decision.
Or you've waived.
Please,
You've waived rebuttal.
You've waived.
Ooh, you've waived rebuttal. That's I like rebuttal time, and the judge is like, no, I don't. First of all, there's nothing to rebut. Okay, there's like literally nothing to rebut. All I said is the court below was correct, and we have nothing more to say. So there's like nothing more. There's nothing to rebut. So there's that too, and like the judge is saying, no, you've waived rebuttal. Okay, well, you know, I don't know how you solve this problem. Maybe a letter, pleading and asking for a new argument or reconsideration, or maybe appointment of new counsel, or I don't know what you do. I think you go have a very stiff drink and try to figure out what the hell happened.
Waived rebuttal. You've waived rebuttal. You're excused.
Take this
You are excused.
gentleman out of the court.
Right now.
Thank you.
Sir, leave.
Okay, well, that was the end of that. There is no more. I feel like we should listen to that entire train wreck again without interruption. So let's just play the entire 3.5 minutes again without interruption, and let's just enjoy the train wreck for all that it is. Practice tips on what not to do.
Doyle versus Palmer. Everyone's here. Thanks.
Morning. I represent Robert Doyle, the appellant. I think our briefs were rather thorough, and at least to my satisfaction, addressed all of the issues, having reviewed the opening brief and obviously the reply brief as well. So my question is whether the court has any questions, because otherwise I'd just be essentially reading from or reiterating the points in my brief, which I'm assuming the court is familiar with the issues. So my question is, are there any questions?
No.
No questions.
I have a question.
Okay.
I don't understand why the appeal is brought. I mean, your client controls whatever affidavit he submits to get admitted, and if it's not an affidavit that he likes, he doesn't need to submit it. So I don't understand why you're here.
It's not a question of whether he likes an affidavit.
His due process concern is that because he has to submit an affidavit, if the affidavit is negative, then that somehow hurts him. But he controls who he gets an affidavit from, and he controls whether to submit it. And if he doesn't like an affidavit, he can go get another one, right?
His fear of a negative affidavit, Judge, with all due respect, has nothing to do with this case. That
was the explanation on what the perceived injury is.
No, it wasn't that at all.
What's the injury?
Are you serious, Judge? With all due respect, I don't know what to say.
You know what? I withdraw my question. You can sit down.
Okay, well, thank you.
Thank you.
Thank you very much, Judge.
We'll hear from...
I see that you read the briefs thoroughly.
Listen, you are acting inappropriately. You are acting inappropriately.
State of shock, I'm sorry.
Well, you are acting in a disrespectful and discourteous manner, and that's not appropriate.
Good morning, Your Honors. Assistant United States Attorney Matthew Montefiore from the Eastern District of New York on behalf of Defendant Appellee. The District Court properly dismissed this action for failure to state a claim, and unless the Court has any questions for us, we rest on our arguments set forth in our brief.
All right, thank you. We'll reserve decision.
You've waived it.
Please,
You've waived rebuttal.
You've waived rebuttal. You've waived rebuttal. You're excused.
Take this
You are excused.
gentleman gentleman out of the court.
Right now.
Thank you.
Yes. Let's go.
Wait, you tell me to kick me out of the courtroom?
Sir, leave.
Well, yeah, so one of the judges ordered him to be thrown out, be removed, and wow, that's horrible. That's really bad. It's like when we did the reaction to Benton versus Blue, and we were listening to like the officer's like attorney, like he was having a tough time of it because his facts were so horrible. And like he was having a tough time, but at least he was respectful, right? And the judges were giving him a lot of slack, and he was trying. They were destroying him because they were so outraged by the facts. But he was being a very good attorney. I mean, he had horrific facts, and the law isn't very helpful, but he was doing the very best he could. And the appeals court was destroying him because he had horrific facts and the law wasn't on his side, but he was being respectful, right? I mean, he was trying for all he was in a really tough bind, but he did the very best he could with nothing. But this guy, like, wow. I mean, wow. I guess should I wait for the decision on this one? I don't know what's happening here, but it's like, wow. I don't even know what the issue is. Like, what is the issue? I don't know what the issue is. The judge gave you an opportunity because the judge said, here's what I think the issue is. I think the issue is your client has a due process concern. The due process concern is he's being asked to submit an affidavit or being required to submit one or whatever, and he's concerned the affidavit might be negative and therefore might harm his due process interests. That's what the judge seems to think what the issue is. And the judge says, well, that doesn't strike me as a due process problem because he's in control of the affidavit. Whether or not it's him or someone else, he's in control of it. If he's the one giving the affidavit, he obviously has control of what it says. If he's asking someone else to give an affidavit, he's in control of submitting it or not. Like, he can't put words in their mouth, but he can control whether or not the affidavit is submitted. If it's not to his liking, he can just ignore it, put it in the client file and pretend it doesn't exist. It's not discoverable. So it's like, I don't see the due process issue here because your client's a master of his case, which seems like a perfectly reasonable line of argument from the court. And then he says, and then he doesn't say, with respect, Your Honor, I believe the affidavit issue Your Honor highlights is a side issue to the principal concern that we have. Our principal concern in this case is blah, 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 blah. We think that this is an important issue because blah, 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 blah. So basically, it's an opportunity for you to very gently correct the court because they apparently are misapprehending the issue. And so it's a very good opportunity. The court just told you they don't understand what the issue is. They think it's something else. And so it's a very nice opportunity for you to very gently correct the court and push it to the side and restate your issue. And so everyone will be on the same page because either your briefs weren't clear or they didn't read them or who knows. But instead, what he decided to do was say like, are you kidding? He said, no, are you kidding? That's not the issue. I mean, that's like, it's like, wow. It's like, well, did he actually waive rebuttal? I don't know if he even waived rebuttal or not, because like, even if he didn't waive rebuttal, there's nothing to rebut. Like, you can only like rebut, like in so much as there's something to rebut. There's nothing to rebut. All the other guy said is the court below was correct to dismiss for failure to state a claim. And we rest on our brief. There's nothing to argue. I mean, there's nothing to rebut because like the court below dismissing was the whole predicate. So it's not like it's new information or new argument. There's nothing even to rebut. And yeah, if the court says he wants to waive his argument, it's like, sure. Wow, this was painful. So I don't even know what the issue is. I want to pull. I feel like I want to pull his brief and see what's going on. But then, okay, then it just gets worse. So according to this article from law.com, New York Law Journal, it says in an interview hours after the hearing, so he's had time to cool down. Does he change his mind? Bank said he could have been more cordial. You think? But he doesn't regret his comments to the judge, Judge Chin. He says, quote, Judge Chin's point, it certainly indicates he doesn't know what the case is about. If only you had an opportunity to state what your point would be. 90% of my case was what my client objected to, rightly or wrongly, the steps he would have to go through to even get the affidavit. I mean, you could have, clarified that. I still don't know what the issue is. Further, he says, quote, it's certainly not something I was planning ahead of time. I certainly think I was understandably very frustrated when the opening comment from the bench clearly shows, at least where I'm standing, figuratively speaking, that at least one judge didn't know what the case was about or didn't care. I assume he didn't know. What an outstanding opportunity for you to inform the court. Maybe they didn't read the briefs. Maybe they got confused. Maybe they got confused with a different case. There's a whole host of things that might be going on. What an outstanding opportunity for you to clear up their misapprehension. Yeah. Further quoting, quote, I'm not aware of any law I broke. I can think of some attorney ethics guidelines that come to mind. They kicked me out of the courtroom, I left. Whether they had a right, I'm not sure. I wasn't being a continuing threat. The judges are pretty much masters of their courtroom. They can kick you out. So, yeah. There's a attached article to this that says how to tell a Supreme Court justice they're wrong. Let's read some of this and see if it tells how to inform it. Well, unfortunately, I can't read this without an account, which I don't have. So, whatever. So, yeah, very, very exciting. All that good stuff. So, let's read some comments. First of all, Spermithicat Nigra. Love you, senpai. I love you too. I love you too. I see you a lot all the time in my chat, and I appreciate that you are here. Yeah, even those that don't have a law license wouldn't have screwed this up. I agree with you. Let's see. Speed run Evil Tribble. Speed run contempt of court any percent. Yeah. It took less than a minute. I'm sure it's been done faster, but that's very good. Yeah, Evil Tribble says repeating with all due respect will get you out of any jam. Not really. And there's better ways to do this. Could you ask for a recess? Not really. Not 1 minute into the argument. You're expected to be better than this. And yeah. When do we get a Rick and Morty animation? Not soon enough. Try for a new hearing. I mean, that's all you could do. You could get a new attorney to petition for re-argument and hope for the best, or withdraw your appeal, or anything would be good at this point. Kurt was cringing. Yeah. So the waiver ball. Yeah, we covered that. I'm out of order. You're out of order. This whole court's out of order. Yeah. Is this suable? Is what suable? What he did in the court? And, well, I mean, you could technically probably sue your attorney for malpractice. Yeah, you could probably sue the attorney for malpractice because that doesn't represent anything resembling good practice. Did Ron Paul of the Bailey think badly so many judges? He's not even a real barrister. He could have controlled himself. Yeah. My strategy is to act like a New York taxi driver in court. Should work perfectly. Not recommended. Not recommended. I think any of us could do better. Pro tips when you're speaking to a court: speak with respect, speak with deference. Remember, they're in a position of positional authority. They are the ones who get to rule on things like your fate, for example. So you might want to, contort yourself accordingly because they're going to literally judge you. They're literally going to pass judgment on you. So you want to behave not like a jerk. So, yeah, the lawyer for malpractice, thank you, senpai. You are very welcome. I love being your senpai, as always. I'm happy that 20 of you joined my impromptu stream that was not announced. So, I appreciate that 20 of you announced my stream that was completely unannounced in every way. I will give you the link to Leonard's stream so that you can go watch his take of it. He called dibs on it, so I wanted to give him the first crack at this out of respect to my friend. So, he called dibs on it. He got the first blow, but after he posted his argument, I posted mine without listening to his. So I'm going to listen to his. Leonard looks like he got 47 minutes out of this. So I don't know what he talked about for 47 minutes, but should be entertaining. And if I have anything further to say on this, then I'll talk about it in a different stream. Maybe we'll go read the original briefs. Maybe we'll figure out what we're talking about and try to figure out what the issue is and figure out how we could have argued this better. It wouldn't be that hard. Yeah. Evil Triple says reading out of the dictionary would be better representation. A little bit, yeah. It just went wrong on every level. So that is all, my friends. I'm going to record a couple videos tonight for new stuff. And as always, appreciate your love on the channel. Appreciate you checking me out. Appreciate you checking out my live streams. Appreciate you checking out my Facebook. If you've not already liked my Facebook page, would be appreciated. And as always, until later, my friends, hope you're well. Cheers and goodbye.